All right, people. We're starting up here. Apparently, I am now live. Got my stuff. Just want to check out a few things. We are going to get on this. All right, we're on. Good to go. So welcome to Garvey's Ghost TV. Take these off. Whoa, sorry. Unplug. So we got a bit of lag. So today, I wasn't going to actually stream today. Some of you have noticed the last stream I did on Thursday was by YouTube. And we know it's because they said I had some medical misinformation and said that, but wouldn't tell me what it was that was actually medical misinformation. So I'm not going to complain about that. Lesson learned. We move on. Today's topic is the Sixth Circuit Court decision that came down yesterday, and that was about the OSHA rule mandate that came out that the Fifth Circuit stopped. So I think it was really important. I think it was the YouTube ruling action actually prompted me to do this because I was upset about it, but I was more upset about what it showed about the concept of justice that is taking over America. So I'm going back to the YouTube one. It's the think of it this way. Imagine someone said you defamed me, right? And they took you to court, say you defamed me, and they wanted to punish you for that. You know, they wanted to get an award, whatever. And in court, all they had to do was say that you defamed them, and then you were found guilty. And if you asked, well, what did I say? They said, no, you defamed me. And the court would say, all right, I rule in favor of the plaintiff, and finally, that's what that's like. And that's so foreign to what American jurisprudence and culture is supposed to be like. And I was like, wow, that's just how it is. So, again, I can complain about that. I've written about people shouldn't be complaining if they don't like it, move to other platforms. So the Ghost is actually on BitChute and Odyssey. So what you don't see here will be there. So without further ado, we are sinking into the USSA, and that's the United Socialist States of America. And you'll see is a reason why I'm saying that, because there was some very interesting and troubling commentary in the ruling that I wanted to point out. Now, just before I get into that, I am not a lawyer. So this is not legal advice. Though you may use some of the stuff I say, I am not responsible if you get fired or something else happens to you. Not me. The other thing is this is a layperson, and I wouldn't discount that, especially if any lawyers are watching, is because people like me end up on juries. And so juries get to decide if the law has been found and what punishment. And so our understanding of the law is significant. It's important. So if you're a lawyer watching this and I veer off into left space, right space, whatever, you just should consider that I have been on juries, and this is the kind of thinking that goes on in juries, and that should inform how you proceed with cases, because there are people like me on juries and who are doing the deliberations in the deliberation room and have influence on other people who may know less or more than we do. So with that, let's switch over and First thing I want to do is a Constitution primer. So for those of you who are maybe from out of the country, some of these concepts may be foreign to you, as in they're not how your legal system works. It's not how your country is set up. For those of you in the United States, and there are a lot of them, who are unaware of how our system works. And so you need a refresher. Maybe it's the first time. I don't want to sound like I'm being condescending, but I just want to make sure I said. So I want to start with the Bill of Rights here. And we have the Constitution here, right? And these are all the articles and sections about what's there. I'm not going to go too far, but to show you it's there. This is, what powers that are granted to different places, different branches of government, and who the president is. That's not really the concern that I have at this point with this. What I'm actually going to look at here is hey, my stuff got moved. Okay. Forward. Oh no. My pages got, here we are. We are having technical difficulties. So there's our Bill of Rights. You don't see that, but I'm going through here. I had the Bill of Rights up, and somehow my Bill of Rights has gone away. I'm not happy about that. Okay, there we are. We have a set of them. Okay, so let me go and back to this. So the important part here, and this will be relevant for the OSHA discussion, is that there are certain things in the Constitution, and the Bill of Rights, which are the first 10 amendments to the Constitution. I'm going to go further than the Bill of Rights, but the first 10. Basically, the Constitution would not have been ratified by the states unless these were added. And what is important about this? A lot of people will say that, the Constitution gives me the right, or, I have rights under the Constitution. And for an American, I can't talk about elsewhere, your rights are inherent. They're not given to you by the supreme document, nor are they given to you by the government. So I'm going to go back here, and it says Congress. So Amendment 1, which is important. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, this is important because it doesn't say, they may not. It's not a suggestion. They shall not. That is a blanket. You can't do this. And so that means any rules that are made cannot establish religion. And establishing religion does not just mean establishing a Church of America. It means also making rules that favor some religious faith over another. And when we look at the Supreme Court decisions, that includes conscientious objections or non-theistic based beliefs. Non-theistic based beliefs are also covered under the First Amendment. So a state, I jumped the gun. The federal government cannot create a law. Congress cannot create any law that deals with establishing religion. And that means we can't make a church, nor can we discriminate against any type of belief. Shall not. Can't happen. Okay. I'm going to go past the second and third and jump to the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant. So this is a conjunction. So you shall not be violated, and no warrant shall issue but upon probable cause. So you can't have a warrant to insecure a person of their self, house, papers, in effect without a warrant. And that warrant is dependent upon having probable cause, supported by an oath or affirmation. So someone has to give probable cause and give an oath, this particularly describing the place to be searched and the persons or things to be seen. So it's a two-part. Shall not be violated. So shall not be violated. Oh, I'm sorry. I was on the wrong. I didn't show that. So my mistake. I'll go back here. Shall not be violated. And if you're going to get a warrant to do that, or basically a court order, there has to be good cause, probable cause, that what you're looking for is you have reason to do that, supported by an oath. That means you have to show some kind of, or make some kind of statement under penalty of perjury that you have a good reason to go into someone's house, to make a search, okay? And you just can't just go willy-nilly, I just want to look. You have to say what you're particularly looking for. So this is very important, and it relates to what we're talking about later. The next one I want to get to is the Ninth Amendment. So what the Ninth Amendment says here, we'll get here, right? So the Ninth Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So what they're saying there is that we listed out, religion and free speech, and you can't have your stuff taken from you, and you have the right to bear arms. But we recognize that that's not the full, complete list of rights that people have, and they are retained by the people. And you be very clear about what they're saying here when they use the term retained. You retain the right, right? Because in our government, the people give rights to the government, not the other way around. So whatever we haven't said, hey, we're going to let you do, you the federal government or you the state or whatever, do for us, right? We're going to give you the right to do this, but we retain everything else, right? So if the state wants to do something different, they need our permission to do it. And if we say no, that's it. You can't do it because we retain the right. It is our rights to give or to decline to give. So that's very important that we look at when we see that ninth thing. And here's the other part again, and this is just sentenced in the 10th. The 10th Amendment. Powers not delegated to the United States, which is what I was saying before, by the Constitution. So by that paper we wrote up, right? Nor prohibited by it to the states, right? So if the states, the states have these other powers, right? Are reserved to the states respectively, that is the 50 states, or to the people, right? So if we didn't give you these rights at the federal level, and we didn't give you these rights at the state level, we retain. They are reserved to the people because they are retained by the people. So that's very important to see that is a huge thing. So the next thing we want to look at are I call this the Civil Rights Amendments. Sorry, the Civil War Amendments. And these are the 13th, 14th, and 15th. For the time being, the 13th I'm going to ignore. The 14th Amendment, so when you people say, well, I have rights under the 14th Amendment, this is what they're talking about. The 14th Amendment has a couple of sections. The one relative to what we're talking about is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states within they reside. So basically when this was said, so since Africans who were enslaved were considered property, once they were emancipated, we became legally people. but property doesn't have citizenship. All right. And prior to this, there were strictures on who could be a citizen, and usually white people. Okay. So in order to put this body of African people who have been stolen from their lands or sold off, one or the other, and then through generations, basically bred into America, they were born here, they're subject to its jurisdiction, then this is what made Africans into Americans as citizens. So that's what that part signifies. And that's really what its only purpose was. It's been expanded to other people, but its purpose was to basically legal status to formerly enslaved people. Former property became citizens. Okay. So the next one is that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, this is important for what we're going to talk about later, that what they're referring to are, again, the rights in the Constitution itself, which I didn't want to go through. That'd take us too long. And then we have the Bill of Rights. You have those rights, and no state can make laws. So when we had the Jim Crow era, after the Civil War and Reconstruction, you had states passing laws to limit what black people could do. And so this 14th Amendment basically says that's not legal. So it's very important. This line is very important because when you have civil rights litigation or claims against a company or a state, this is where it comes from. And the Civil Rights Act, Title VII, Section 1983, which is where most civil rights cases end up, with discrimination cases start from. This is where it stems from. So this Section 1 of the First Amendment, 14th Amendment. And no state shall deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws. Now, this is important because when they talk about equal protection, remember I mentioned the conscientious objector status being the same as religion because it deals with the Establishment Clause in the First Amendment. This is how you claim, hey, I've been treated differently because I'm a religion, I'm a Muslim, or I'm a traditional African religion person, or I'm a Christian, or I have no religion at all. I can't be treated differently because of those beliefs than other people similarly situated. Okay, so this is the section that's really important when you're looking at that. So you have Section 1 of that, and I just wanted to make sure that you saw that because this is really, really important to see. I believe there is one other section that I wanted to look at, and it should be, where is it? No. This might be going back to the Constitution itself. Bill of Rights, and we already did that. Constitution of the United States. It was in, right. So Section 4, right. So this is one thing. Article 4 of the Constitution. Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion, blah, blah, blah. Now, this is important. When they say Republican, they are not talking about Democrats and Republicans, right? There were Whigs back then. That was a party. So no, they don't mean Republican. Republican means it's a representative form of government, with our legislature. So what we have currently going on under COVID is this emergency government where governors are just declaring, we just going, you need to do this, you need to do that. And legislatures have not been passing laws. So I see it, we are running afoul of this particular part of the Constitution because we're supposed to have legislatures and they're supposed to take votes and be held accountable by the people for those votes. Now they know this, so what they do is say, well, we just give emergency power to the governor and it's the governor's fault if something goes wrong. See, they don't want to take responsibility. And that's why they're doing that. And that's why they try to put everything on the governor or the president or the mayor, and they try to do that so they don't have to make decisions, right? Because then they'd be held accountable by people who say, hey, you know what? You decided we're going to shut our businesses down under law. We're putting you out, right? But they don't have to say it. They say, hey, the governor did it. It was an emergency, right? So that's what that's about. So I hope this kind of helped, because I really needed to let you guys know what that the basis for a lot of our laws and rules. And then when we look at this ruling now, you'll see, hey, this is not necessarily good. So let's get to the PDF viewer here, and we can see OSHA. Okay, so this is a pretty long ruling, so this might take a while for us to go through. All right. So basically on Friday, the Sixth Circuit dropped this on us. And when I read it, I was really concerned about some of the language I saw in there. And if you follow my blog, you'll notice that I've been writing about language being used in media that tries to get you to think certain ways. This is not one of those, but it's still something concerning language. So in mind of what we saw with the Constitution, I want to look at this material. So let's scroll down here to the beginning, and I'm just going to read the opinion. So the first thing right out the gate is Jane B. Stranch, Circuit Judge. COVID-19 pandemic wreaked havoc across America. No, it is not. You say, how is that so? We'll get to that. Leading to the loss of over 800,000 lives, shutting down workplaces and jobs across the country, and threatening our economy. Now let's get something real clear here right now. Okay? COVID is a virus. All viruses do is float around, infect people, infect cells, inject their genetic material into the cells, get them to replicate, exit the cell, and go to the next. That's all viruses do. Viruses aren't even technically considered living. Bacteria are alive, fungi are alive. In fact, viruses are not considered alive. And that's not medical misinformation. That is actual fact. Okay? So when someone writes this, that COVID has done this, or the pandemic has done this, what was really the case, it's that they did it. Like the government's response shut down workplaces and jobs across the country and threatened the economy. The other thing of this is the 800,000 lives. Yeah, apparently 800,000 people have died, and that's a cumulative as of 2 years. Let me ask you a question. When have we ever broken out or just combined yearly deaths? Do you know that about 3 million people in America die every year? Can you imagine if we just said, well, from now on, we're just going to keep counting the deaths? So last year was 3 million. So this year it's 6 million. And we just going to keep adding those numbers up as if there aren't cycles to this thing, right? So that bothered me when I saw that. So let's go here. So recognizing that the old normal was not going to return, employers and employees have sought new models for a workplace that will, right, the safety and health of employees who earn their living there. Yeah, who broke the old normal? And then you figure that out, then you know why people were asking. Because the government came in and broke the normal and decided it was going to break the normal and then say no every time someone wanted to do something. So again, that's the government. It wasn't that if the government had done nothing more than, hey, we see disease out here, we're working as far as we can. This is information we know. Be careful. This is what we know you can do to help yourself. There wouldn't be this having to look for them to get to some new normal. Okay. So So there's here the businesses return to the Occupational Safety and Health Administration, the federal agency tasked for assuming safe and healthy work. Again, they didn't do that. It was the government. The government did that. So this just tells you exactly where this woman is thinking when she's letting us know her mindset and her opinion, because this is not necessarily facts right here, and courts are supposed to deal with facts, not opinions. Let's move forward. All right. So Congress passed the Occupational Safety and Health Act of 1970 and established OSHA to assure safe and healthful working conditions for the nation's workforce and to preserve the nation's human resources. So this is a very important part, because when it was established, like I said, to assure safe and healthful working conditions. Now they're gonna get back to that, to expand what working conditions means, but we'll go all right. That's right. So going, it expressly found that personal injuries and illnesses arising out of work situations impose a substantial burden upon and are hindrance to interstate commerce in terms of lost production, wage loss, medical expenses, and disability compensation. Right? Again, personal injuries and illnesses arising out of work. Right? So the logic before that was that, let's say you work on a construction site, you got to wear this hard hat. You work for the transit authority, you got to wear a certain kind of shoe. You got to wear a certain kind of uniform, right? You got to walk in a certain way, and there's got to be certain signage up, okay? All those are what OSHA was doing before about personal injuries and illnesses, sick leave, so that kind of stuff. So, like I said, this is what it was when this was going on in 1970. All right, so let's go down. All right. Before issuing an ETS, OSHA must determine that 1, employees are exposed to a grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards, and that an emergency standard is necessary to protect employees from such danger. And again, this was for, you work in let's say you're doing construction and you got to clear asbestos, right? Asbestos will give you cancer. It is unique to the workplace. It's not just some general thing, right? So that is what was understood at the time of the creation of OSHA and allowing it to make these rules. And you'll notice, again, it's the places of employment, right? This is very key. This is what they said. Watch what happens later. All right, so the next one is, now they talk about the emergency rule, and this is kind of important, because they came out and said, well, this ETS does not require anyone to be vaccinated. So what they're saying, this is not a vaccine mandate. It's very clear, right? Rather, the ETS allows covered employers with 100 or more employees to determine for themselves how best to minimize the risk of contracting COVID-19 in their workplaces. But remember, COVID-19 is an airborne virus. So that means, unless your workplace is hermetically sealed, how do you keep out viruses? I'm just asking a question. Any virus, right? So that's right. So it at 6, I guess that is the page number of because the ETS is huge. It's huge. So I guess that's what they're referring to. All right. Employers have the option to require allowing employers to opt out of any vaccination policies. Now, so what she's saying is that the ETS, unlike how it was being talked about, was not a vaccine mandate, because the employers could opt out of the vaccine part. I think this is the judge throwing the employers under the bus, because by saying that OSHA's not saying you have to make your employees get a vaccine. You make that choice. And so the liability then goes on you, the employer, rather than the federal government, because the federal government didn't say you had to do it, right? So employers have the option to require unvaccinated workers to wear a mask on the job and test for COVID-19 weekly. They can also require those workers to do their job exclusively from home, and workers who work exclusively outdoors are exempt. So she says it is, get back to that page, the employer, not OSHA, that's what I was saying, can require that its workers get vaccinated, something that countless employers across the country have already done. This ETS offers employers a choice on how to comply. So, arguably, any business that makes a vaccine mandate rather than a vaccine or a test mandate has made the choice themselves and cannot claim that it's the federal government making me do it. And this is assuming that this doesn't get tossed by another court or the Supreme Court, right? Just assuming that this just stays as it is. So it's the employer's choice. So if employers decide, hey, you got to take this shot, the question is, are they liable, since they, per reading this, are the ones that made the decision, not we're just trying to comply with the government. So take it up with them. All right, so that was something that was very interesting to me when I read that, and it changes kind of how I think this is going to go, because the arguments have always been, they can't force you to take something. So this would be interesting when it goes to bigger courts. Now, the next thing on this I found interesting is the act is a part of an act that requires OSHA to issue an emergency standard if necessary to protect workers from a grave danger presented by exposure to substances or agents determined to be toxic or physically harmful or new hazards. So that was a rehash of what was said earlier. But notice that the terms of grave danger. Grave danger becomes the standard. But again, when it was going into 1970s, the purpose of that was for asbestos, people who work with chemicals, people that work with metals, even people who work in hospitals. You have blood, you have people with infectious disease, you have people who work in laboratories, like the one in Wuhan. So they got to wear all kinds of stuff. That's what this stuff was really about. It was never, ever, ever used about regular, like common colds, flus. It was never used for that. But this is this, and I keep repeating that. And I know it's like you said that before. I just want to get that point across. It's very important. We're going to see this later. So the other thing is grave danger, and one of the things that people have said that certain groups have less reactions than others, or less mortality than other groups, and they're going to address that later. So I wanted to show that, and right. So because of that grave danger, they're saying an agent that causes bodily harm, a virus, falls squarely in the scope of that definition. Now, this is where we're starting to see where the court is trying to now change the scope of OSHA's responsibilities by taking advantage of vague language. And this is going back to the Constitution itself with the whole due process. Without due process. Due process is whatever the legislature makes it out to be. And whatever a court decides the legislature is okay. Okay? So because OSHA's mandate was grave danger, well, you can just put almost anything as grave danger. And this is what the court did. Well, we need to give OSHA cover. So virus is deadly. It's a grave danger and it kills people. and therefore OSHA is not responsible. So one lesson out of this is we need to be very careful at these laws that are really overly broad and vague. There's a lot of them out there. And that's what it is. And you'll see other provisions of the act. Start reading this part again. Other provisions of the act reinforce OSHA's authority to regulate infectious disease and virus, as explained above. Congress enacted OSHA under the Commerce Clause because Congress found that illnesses arising out of work situation impose substantial burdens upon interstate commerce. And again, I'm not a constitutional scholar by any means, but a lot of people say a lot of abuse happens due to that Commerce Clause. That Commerce Clause has been responsible for a lot of rules and stuff that otherwise couldn't have been done. So I want to point that out. Next one here. So here we have that provisions also contains a religious exemption for the entire OSH Act. Nothing in this or other provisions chapter shall be deemed to authorize or require medical examination, immunization, or treatment for those who object thereto on religious grounds, except where such is necessary for the protection of health and safety of others. Now, remember we were talking about the Constitution, right? Shall not. And here we go. Well, except for shall not. So we either are dealing with shall not, or we're dealing with, well, except for here. I don't like the except for here. This is why my Second Amendment ideas have changed, because I understand now the dangers of intruding on shall not. If it's a shall not, it's a shall not, period. So, again, and I also object to the use of religious grounds. And again, I explained that earlier when I was discussing the First Amendment, that because conscientious objections or conscientious of other kinds of belief that are not theistically based are also covered by the First Amendment that was already established by the Supreme Court. So we should not be talking about religious grounds. We should be talking about First Amendment grounds. And again, the First Amendment is a restriction on government, not a restriction or a right given to a person. Okay, so that's another of my objections. I see this actually outside of the court system. A lot of lawyers say, well, religious exemption, no. It's a First Amendment exemption. And we need to change our language and how we speak so that we can see it. It's a First Amendment issue, not a religious issue. So, so that also means, again, that employers have to take into consideration these issues, and some of them are running afoul. I was watching a video on United, who's been doing some really nasty things to its employees, apparently, and there's that. So I don't know how that's going to affect them, but I just want to point that particular thing out. This was interesting. In 2000, Congress passed a Needle Stick Safety and Prevention Act. Now, this is great. Directing OSHA to strengthen its bloodborne pathogen stand to provide language for the regulatory text. Now, needle sticks. Remember, I was saying when the OSHA was making these rules, it was really about, again, hazards of the workplace. Like how many people, like OSHA is not, you got pins in your house, right? You got needles in your house, right? Right? Even if you're a diabetic, I'm going to use that example. You think OSHA's got a rule about how you use your needle and whether it pokes your kid or someone else in the house? No, there's no grounds. It's not the workplace. But at the job, they can't just have needles just willy-nilly everywhere, right? That's an OSHA violation. So, and it's funny because this Needle Stick Safety and Prevention Act is a classic example of OSHA is talking about workplace. So we're talking about schools, we're talking about hospitals, other cares, and you just don't want used needles, sitting around that have been stuck in someone who may have a disease. But again, this is not on the person; it's about the needles. So that I just thought that was an interesting thing. But again, The other part to this is how Congress was expanding the authority of OSHA. And this expansion is what we're seeing, this growth of government agencies in America, which is an issue. Based on OSHA's Act in 1991, it promulgated a standard regarding exposure to bloodborne pathogens. OSHA also promulgated a standard requiring employers engaged in hazardous waste cleanup to protect against any biological agent and other disease-causing agent that upon exposure, ingestion, inhalation, or assimilation into any person will or may reasonably be anticipated to cause death or disease. Requiring the use of respirators to prevent occupational disease caused by harmful dust, fogs, fumes, mists, gases, smoke, sprays, or vapors, and requiring employers to provide adequate toilet and hand washing facilities to protect workers from pesticides and prevent the spread of harmful bacteria and disease. So again, right, it was about the people, right, what was it? Right, hazardous waste cleanup. Again, are they saying that people who are, I guess, not symptomatically sick are hazardous waste? You can interpret it that way, right? That they're saying that if OSHA has the rights to do this under their Control Act, right, then people must be hazardous. This is the mentality to even, because if I wrote this, I'd be like, wow, I'm calling people hazardous. That's kind of xenophobic, but hey. But again, this is the expansion of this rule and giving OSHA more power for a good cause, the tyranny of good intentions, right? Right. So the use of respirators, and this is where they're going to get to, this is how they're going to justify the mask part. Because, hey, we require people to put stuff on their face before, right? So we can do it now because the grave danger, right? This is how they're building that block. This is how they're building their house. And then they talk about the use of common drinking cups. I remember I saw a post somewhere where someone was showing old cups. I think it was back when polio was out. But anyway, and courts have upheld OSHA's authority to regulate hazards that coexist in the workplace and in society, but are at heightened risk in the workplace. Now, this is something I saw. I think I was watching Viva Frey and Barnes Law, and they were talking about how the issue with the OSHA ruling is that OSHA is strictly workplace, and that because they're dealing with something which is outside the workplace as well, equally, then they can't make this rule. And this is addressing that issue. But the way they're getting around it is saying you're more at risk, and I'll get to how they get to that, by being in the workplace than being anywhere else. And therefore that gives OSHA cover for making this rule. Now, there are papers that suggest otherwise. Until I can actually put them into the video, I'm not going to discuss them because, I might put this elsewhere. So that's what that is. And it's important because they talk about the heightened risk, because that's going to be their out when, how are you covering for stuff that's present elsewhere than the workplace? All right. The responsibility of the act imposes OSHA to protect the safety and health of employees. Moreover, it is hard limited to hard hats and safety goggles. So you remember earlier I was saying that, when this was started, hard hats, boots, that kind of stuff, the vests, those yellow vests, all right, it's limited to that kind of stuff because you can take that off when you leave work. All right, so now they're opening this up, and they're showing how Congress opened that up. So OSHA has wide discretion to form and implement the best possible solution to ensure the health and safety of all workers, and historically exercised that discretion. Having been charged by the act with creating such health-based standards, it makes sense that OSHA's authority contemplates the use of medical exams and vaccinations as tools in its arsenal. So basically, you're saying that OSHA can demand that you do some kind of test. Now, that's not unheard of. There are places where you have to take a drug test. That's part of OSHA, because they're saying if you're impaired under the influence of drugs, that you're a danger to your coworkers. So again, that's where they're pulling that from. That you being impaired creates a danger to others, and they're just extending that to say, well, you might be infected, therefore we can consider you a danger to others, and we can test you. So that's where they're getting at, and as long as they can claim that you'd be a danger to others, there's their cover. And so it'll be interesting of course, you're gonna have to address that, what that would mean. One of the things I'll say with that is the difference with the vaccinations. Again, you can't get unvaccinated. So again, with everything else, even with testing, you test when you're at work. If you don't go to work, you don't get tested. You go about your business. Whereas with a vaccine, once you've taken it, you are vaccinated for life, and whatever else happens after that, that's outside of work. That's it. So that's something that may be argued in a certain thing, but I just wanted to show that. The next one is the language of the OSHA Act plainly authorized OSHA to act on its charge to preserve safe and healthful working conditions for the nation's workforce and preserve the nation's human resources. Again, that's just a reiteration of the other ones. So the next piece that I have, skipping. There's more. I know there's more. Where is it? There we go. So remember before I was saying about how many people had died, and that there's different mortalities in different groups, right? So this is where the court is saying that, where it also has killed 725,000 people in the United States in less than 2 years. Again, the craziness with not separating out different years, because we know this is a seasonal virus. That's another discussion. And we don't do this for other diseases. We say COVID-19 affects individuals of all age groups, but on the whole, working age Americans 18 to 64 now have a 1 in 14 chance of hospitalization when infected with COVID-19. Yeah, if you stretch out 18 to 64, I guess you can get to that number. But we know that from 18 to 40, you have one set of risks. And after about 50, so say 18 to 49 is one set of risks. And really, it should be 18 to 30, 30 to 49, and then 50 and up. Like your risks just skyrocket. So I just want to make sure we understand that, but that's how they got that 1 in 14, because they made a very huge group to represent the workforce. And what they're saying is that taken as a group, this is their risk. And of course, it's weighted heavily, because say if you have a 1 in one hand, so they're averaging 1 in one hand, and you have 100 in the other, your average is going to be 50. Your median is going to be, your mean is going to be 50. Your median, if you don't have 50 as a middle number, then it doesn't exist. But if you have 1 in 100, your average is going to be 50, even though it's one side that has that 100 versus the one on the other. So that's just it's a mathematical trick they're engaging in. But that's but they're making these statements, and I think these statements, if they're going to try and appeal this, I think these statements need to be addressed by the plaintiffs, because they will need to really get at the thinking of the court, and they need to attack that hard. So here we go. Now here's where it's funny. Where OSHA estimated that the standard that their ETS would save over 6,500 worker lives and prevent over 250,000 hospitalizations over the course of the next 6 months. Where'd they get this number from? They're going to answer that, but anyone who has been following this COVID stuff knows full well that there have been models that have been catastrophically wrong, just epic. I mean, orders of magnitude off. We can go to Sweden the models for Sweden, basically killed off half the country. I'm kidding. They didn't kill off the half the country, but basically they were like, it's just going to be death. And then when Sweden was done, after doing nothing like the United States or the European Union, it was way off. I forgot the name. Neil Ferguson's predictions were way off. So, again, plaintiffs need to address that and say, we have so many examples of where predictions were made that were totally wrong. And in government, we should not be submitting people to irreversible medications with what we think is going to happen. It should be what we know is going to happen. That's my opinion. It says, as the death rate in America has continued to climb throughout 2021, those estimates have proved to be understated. If you say so. Bill Chappelle, 800. So you got this from NPR. And that just tells you everything you need to know, because these judges, like everybody else, have biases, and they watch the same programs and are getting the same programming as everybody else. And as smart as they may be, that fear that's living in here, they need to rationalize that. And so they're subject to the same thing. And so when you see, NPR, like NPR is not Lancet, okay? NPR is not the doctors in the Great Barrington. That's not NPR. There should be no NPR, none, in a judgment. That it should be either a journal of medicine of some sort, but don't put NPR. And I think the plaintiffs need to hit that. Like, NPR are not doctors, period. They're not researchers in the field. No, and no. So you go back to this PDF. And where a grave danger exists in the workplace, of course, OSHA may consider statistical proof on lives saved in hospitals and prevented when issuing an ETS, even if the risk for individual workers varies in workplaces. So this is where they address that whole, even though there's this really big group, 18 to 64, and the 18-year-olds are next to no risk, and the 64-year-olds, particularly if they have comorbidities, have a whole lot of risk. We could ignore that these individual differences happen because it's a grave danger to somebody in the workplace. And as long as it's a grave danger to somebody in the workforce, then OSHA can step in. And that's their basic take. So again, they're reinforcing that through their decision. OSHA point to extensive scientific evidence, including studies conducted by the CDC. We therefore cannot say that OSHA acted improperly in light of clear reliance on a body of reputable scientific thought. Okay, let me tell you what this is like. So imagine I'm making an argument and I got family members on my side and I'm making an argument with somebody and I say, well, I'm making a good argument because my mom agrees with me and therefore my argument is good. Right? So this is what these governments do. So OSHA is basically saying, OSHA as an agency of the government is saying that it looked at the studies done by another arm of the government and came up with its conclusion, and that's why it's good. Not that we looked at third parties, right? Third parties who have either no interest, right, or dispassionate. They don't care either way, right? No, we took the CDC. Okay, but what the CDC says is rule. So hey, there you go. So the claim that COVID-19 exists. Oh, sorry, I'm moving on. Claim that COVID-19 exists outside the workplace and thus not a grave danger in the workplace is equally unavailing. So it's basically saying just because COVID-19 is floating around outside because it's airborne, and therefore is is a danger to people outside the workplace, does not mean that OSHA cannot rule in the workforce. And again, I saw this argument being made, I guess it's on Viva Law and Barnes, that was going to be a stumbling block for them. And I guess this is their answer, that it doesn't matter if that thing is inside and outside. In fact, that it's inside and we have control over what's inside because we can do something about viruses on the inside. Hey, it's unavailing. So that's what that one is. So let's go to the next piece, right? So she goes on. So remember before they were saying about how many cases and how dangerous it is. And it says within 1 week in mid-November, Michigan had reported 162 COVID-19 outbreaks. 157 of them were in workplaces. Tennessee reported 280 COVID-19 outbreaks. 161 of them were in workplaces. Washington State reported 65 outbreaks, of which 58 were in workplaces. And other states similarly experienced outbreaks predominantly in the workplace. And my answer to that is duh. Wherever people spend a lot of time with other people, they are going to have outbreaks. And I'll give you an example what happened in New York. So in New York, when they had the lockdown, Governor Cuomo, he was shocked to find out that people in their apartments were still getting infected. All right, there was a report, and it's like, all these people were coming cases, and he was like, what's going on? How is it? Because they're not at work. Because the virus is airborne, and airborne viruses are not restricted to, work. They don't just disappear just because you walked in or out of a door, and that's one of the things that that we know from New York. So if this gets appealed, I would suggest that the plaintiffs point out what happened in New York. I believe Hong Kong had a similar issue with one of their hotels. I think it was a hotel where a person on the top floor was infected, even though he had no contact with anyone else. And the suggestion was that it went up through the plumbing for the toilets. I think they lacked P-traps, and the P-traps would, because of the lack of P-traps, the air was able to come up out of the toilets and infect people. Don't quote me on that. I do know that's what the story is, but I don't know the details. I'd have to find the article again. But the plaintiffs are going to have to address that, and they should show that it's just where people are. And as long as people are congregating, people are going to get infected, which is why when you're outdoors, just in the park by yourself, there's no real issue. It's, we have to deal with crowds. But that's with every disease, whether it's the flu. Last time I caught the flu, I was in a casino. Someone sneezed right over my head. I felt the splatter. He was coughing, and I knew I was going to get sick, and it happened. And that's where it is. And I don't blame him. I mean, I blame him because he was sick. He knew he was sick and came to the casino anyway. But I blame, I don't hold him, OSHA should get on the casino's back. That was him. And I had to take care of myself. So that's a hey, Master Distiller. I see you. I'll comment on that real quick when I'm done. But yeah, so I just want to say that's how they're answering, and the plaintiffs, with their appeal, are going to have to deal with that. So again, they go again with the we know that in our nation, 800,000 people have died in less than 2 years, and the numbers continue to climb, with more and more deaths have occurred in 2021 than 2020. And I think that's a good point. And I would add that we've had a mass vaccination campaign going on since December of 2020. So we are a full year into vaccination. And the numbers, according to this judge, I'm not saying this, YouTube, according to the judge, the deaths and case numbers continue to rise with the vaccinations still going and boosters. I'm just going to leave it at that. The next one here is so some petition argued in such say mandates that OSHA standards may use only means that are absolutely required to quell a danger. So this is the either you can do your mandates have to be 100% effective, or it can't go on. So if the plaintiffs actually made that argument, I would say that was pretty bad, but it is an important point. So taken seriously, such a cramped reading of the statute requires to prognosticate an emergency and devise the most narrowly tailored ETS to entirely remove the grave danger from the workplace. Now, one thing that's interesting is this admits that OSHA cannot eliminate a danger. It can only reduce it, which is kind of different than in, let's say, asbestos, right? The rules they have in place basically eliminates the danger because you have to wear certain things. The houses have to be sealed off when that stuff is being removed from walls and ceilings. I watch a lot of these home improvement shows, so I see this a lot. Like there are really strict things that they have to do with how it's disposed, how it's bagged up, so it basically does eliminate the danger. But hard hats, you can still get a concussion. You just probably won't get gashed, something. So I can see how they're saying that. But going back to the piece here, but in virtually every emergency situation that require an ETS, no precaution proposed by OSHA could ever be 100% effective at quelling an emergency. So I think they're actually right in this sense. Yeah, no rule, nothing is 100%. They should think about that when they are talking about the mandates. Nothing is 100% effective, and there's that. So the next piece on that, we're getting to why I call this the USSA, where they say that vaccinated employees are significantly less likely to bring or, if infected, spread the virus in the workplace. All I'm going to say is there are papers out there that have come to a different conclusion. And maybe I'll do a piece on that, and it probably will be on BitChute and not here. So that's all I'm going to say on that. And I would hope that the plaintiffs address this particular sentence right here, because it can be dealt with. I'll just leave it at that. So going back again, the OSHA is required to minimize grave danger, even if it cannot eliminate it altogether. So we discussed that, and those are the rulings. The Fifth Circuit did this in 1988 when they made that rule. So again, they're building on other decisions and other legislation done by Congress and other rulings of courts. So here we have OSHA found that unvaccinated workers work in the workplace where they encountered other workers or customers faced a grave danger, and that vaccination or testing and masking were necessary to protect these workers from COVID-19. Apparently not 100%, right? But somehow, but here's, again, and this is the other thing with risk. If you're talking about the unvaccinated workers, so the workers, again, anyone who decides not to take a vaccine, they're assuming the risk for themselves, and they have a right to do. And I'm wondering why OSHA, I guess OSHA could say, well, yeah, you can take the risk of going to a job site, say a construction site, and not wear your hard hat and get knocked in the head. Would you take that risk? Is another story. I guess the level of risk that you would face. I wear a hard hat on a construction site because you won't see a large beam coming towards your head, which will kill you instantly. So my perception of risk on a construction site is way different than that of an airborne virus, with a current 99% survival rate. But you get knocked in the head by a large beam on a construction site is probably not going to be good for you. But anyway, they're also saying the customers. So again, I can see where, following their logic, OSHA has this can make this kind of claim. And again, I'm following their logic. I'm not saying I agree with it. And that's one of the purpose of this live cast is to really discuss it, not whether you agree with it or not, but to think of the logic that they're using, because that's the important thing to look at here. So last one is again. So if you saw earlier, I was like, well, how many people, when they were saying they thought it was going to save 6,500 lives. I was like, how do you come to that conclusion? Well, here she goes giving them cover again. It has long been the case that an agency is not required to identify the optimal threshold with pinpoint precision. It is only required to identify the standard and explain its relationship to an underlying regulatory concern. In other words, they can just make up a number, and hey, you just got to accept it, right? And courts are generally unwilling to review line drawing performed by the agency unless the petitioner can demonstrate the lines drawn are patently unreasonable and have no relation to the underlying regulatory problem. And this is why I said earlier that if the plaintiffs are going to appeal, they need to get at these statistics, the 800,000, whether unvaccinated and vaccinated people are able to spread or not. To the extent that they can spread, they need to address those. And there are papers that are out there that can get them to do that. And they need to get real familiar with them. And they need to attack that head on. They are not going to get this thing overturned by just arguing this law, this legislation, that. They're not going to get by with that. Not what we're seeing here. So I hope they're doing their work. Right, and she's telling us that the court's not going to do it. The court's not going to do it for them. They're not going to do the research. You got to present that information. So the next line I have here that I highlighted, they're dealing with the Commerce Clause. And I said the Commerce Clause is something that has been pretty damaging. But here's the thing, that the first petition raised challenge to ETS under the Commerce Clause, directing us to the Fifth Circuit's conclusion that the ETS is likely to exceed the government's authority under the Commerce Clause because it regulates non-economic inactivity that falls squarely within the state's police power. Now, this is the reason why I'm concerned about this, and this is something I've been telling other people, is that the big problem here goes back to the constitutional issues that I brought up prior. We have got to get back to the point where you have an inalienable, inbred right to certain things, and the government cannot cross the line, period. What these guys are doing, and I understand lawyers do that whole kitchen table thing, kitchen sink thing, you just throw everything at them and see what sticks. But basically what they're doing is moving the mandate from the federal government to the states. We're saying, well, the states can do it, right? The states had the power, not the federal government. Well, dude, we all live in states. So it doesn't solve the problem. It just moves it from one place, one person, or one entity to another entity, one government entity to another government entity. You're still under the government's thumb. And the point is, the thumb needs to go. That's what we should be addressing. So this whole thing about moving it from the state, and because the state has the power and the federal government's encroaching on the state, that's a side point in my view. And as each individual, as an individual citizen, I don't want the state having this power either. So that's something that they'll need to address. They're probably not going to address it here, but it's something I would like to see lawyers deal with. The state should not have the power either. Again, using the 14th Amendment that we discussed earlier, that says that these rights that you have from the sovereign document, the Constitution, flow right down, and the states can't even do it. So that's where that one goes, and they talk about who it regulates. And then here's the thing with the Commerce Clause. Now remember, I said this about the Commerce Clause. That's a dangerous clause they have there, right? So to hold otherwise, and what she's saying is to say that the Commerce Clause prevents OSHA from doing what it's doing, right, would upend nearly a century of preceding precedent upholding laws that regulate employers to effectuate a myriad of employee workplace policies, right? Fair Labor Standards Act, right? Minimum wage. So now all these social things that you like were done under the Commerce Clause. So she's saying if you eliminated the whole using the Commerce Clause for stuff that's not economic, whatever, well then you lose minimum wage protections. Now there's a lot of people that would be okay with that. I'm not under the impression that that's necessarily a good thing for other reasons, but just want to say that. So you really have to see that the arguments you're making, there are flip sides to it, and I hope that the plaintiffs are going to look at that and say, hey, we may not want to make this particular argument because it could undermine something else. And again, I said that's why I said you can get to the core of the rights held by, retained by the individual, and go from there, rather than go from, well, the federal government, state government, da, 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 da. No, ours is from the person up, not from the federal government down. So this one here, when industries occupy at the national scale, moreover, Congress may protect interstate commerce from paralysis. So basically, they're making that argument that because everything was shut down by the government, OSHA has to address the problem created by the government of paralysis. Well, how about this? How about you rule that states just can't make these kind of emergency declarations? That solves the entire problem. There will be no paralysis. Then people, as individual citizens, say, you know what? I don't feel comfortable going to the store, or I don't feel comfortable going to the supermarket. Whatever it is, I don't feel comfortable going to the mall. I don't feel comfortable going to the movie theater. And those who are, they go about their business. And so, until the people who are uncomfortable, that's how it should have been. All right. You make the decision, not the government. So the government created the problem. And now you're saying, well, we have a solution for you. Put this in your body. So there's that one. And I think that gets me to the title of the piece here. Right. Yeah. So here's the thing that jumped out at me and made me say, you know what? The ghost is going to have to make a presentation tonight. By contrast, the cost of delaying the implementation of the ETS are comparatively high. Fundamentally, the ETS is an important step in curtailing the transmission of a deadly virus that has killed over 800,000 people in the United States. Again, she's hitting that number, right? Brought our healthcare system to its knees. Yeah, but you're firing nurses and doctors. But you're concerned about the health system, but you're firing nurses and doctors. Point that out. Forced businesses to shut down for months on end. No, the government forced businesses to shut down for months on end. Government did that. Government created this problem and cost hundreds of thousands of workers their jobs. The government did that, not COVID-19. The government did that. When the governors and the mayors and all those people said, you need to shut down your business, 2 weeks to flatten the curve became months and months of flattening the curve or whatever it is you said you were doing. You cost those jobs. It's a government created problem. When those restrictions were lifted, people ran out their houses to do stuff, showing that they were willing to go if they were given the opportunity, or say retain the opportunity. So they need to address that. Again, the plaintiffs have to address that it wasn't the pandemic. It was the government's response to the pandemic, right? And lastly, and this is why I say this is the USSA, that the harm to the government and the public interest outweighs any irreparable injury to the individual petitioners who may be subject to a vaccination policy. I want to read that again because this is what I think is the mask falling off. And people know the mask has been falling off for a while, but this is why I say the mask is really falling off. Notice what this is a judge, one of the branches of the U.S. government says. The harm to the government. Since when is it the court's job or OSHA's job to protect the government? The government was created by the people to protect and secure the rights of the people. They got the whole thing backwards. It is not the job of them to make you to protect the government. So these people are self-serving, and they just admitted it, right? And the public interest. That's the socialism. That's why I said USSA. Yo, this is full blown. This is what she's saying. This is a person on the courts. So as Master Distiller's over there talking in the chat, and I see you guys. This is what it's saying. The courts are being compromised. Whole levels of government have been compromised, and she's stating publicly, without shame, that it is your job as an individual to protect the government from harm, right? And that the government's well-being is more important than irreparable injury. It is irreparable injury to any one of you. I mean, do you understand what they are saying? Right? You are disposable. That's what this judge just said. You are disposable to protect the interest of the government and those who have public interests. And when I saw that, I was just like, wow, that's just bad. And this is coming to the end of this rather long. I think I'm going for an hour and 15 minutes. That doesn't include the preparation I did this morning for this. But I'm just telling you, when you see this, I was just, when I say I'm shocked, I don't mean I'm shocked that they're so bold now, because I kind of knew, well, see, that America is a corporation and businesses are run for the sake of the shareholder, to profit from the ownership. But you got a judge that wrote this and didn't even pause. That it wasn't even like, yo, that doesn't sound right. And that's where we are. So, that they don't care. They don't care. And they said it right there. You can have an irreparable injury due to this ETS, and they don't care, because your rights, your inalienable rights that shall not be, right? Shall not be abridged, shall not be established, shall not. That's gone because the government cannot be harmed. So that's the thing you need to think about for the rest of the week. Is this what we have here? And this is what you want to subject yourself to, because this is back to King George days. You're just a subject. That's basically what you said. You're a subject, right? You're not a citizen. You're a subject of a government that cannot be harmed. So I think that the petitioners, the lawyers who are supposedly going to petition to the Supreme Court, and I don't know if there's another court between there. Again, I'm not a lawyer. I think they really need to get in these things that I've highlighted, and they need to address the whole fundamentals, right? At least get the stuff on paper. You need to deal with how the seasonalities, the numbers, the projections, and how projections have been wrong. The level of vaccines that's going out, and you still have these cases rising, and you need to get this evidence in places where we have doctors who predicted that there may be an issue where certain things could happen if you have a mass campaign. And I'm going to leave it at that. Again, I might discuss that on BitChute. But they're going to have to really address these things if they even want to think about it. And I'm going to be completely honest. I don't think the Supreme Court is going to take this down. And even if they did, it's going to take a long time. I don't see them granting some kind of emergency. And I think we're going to run to January. I think this thing's going to get kicked right back in. We're going to run to January, and at least, and a lot of rulings that's supposed to be coming out of that. I was watching a video of a truck driver that's talking about 15% of truckers who are just not going to deal with this. I'm going to tell you right now. I didn't say this last year. I'm going to tell you right now. You better get to the supermarket. You better buy some non-perishable goods and stock up, because I'm telling you, these people, they don't care. They just told you they don't care about your irreparable injury. They don't care if you starve. They don't care if you starve to death, if you run through all your money. They don't care, because you can't harm the government. So that's it for, let me look at, before we hear this real quick. I just want to just get on. I saw this chat. Yeah. So the woman is 100% control. I just wanted the thing with that. So you're looking at, I guess that's the abortion thing. So that Roe v. Wade, right now you have the Texas, that's the Texas SB 8. The ruling on that is that's going to be coming down. The law in Texas that they're looking at really doesn't have to do right now with who controls the body. They may discuss it, but right now it's about who can sue. So I can't really say too much about that legally wise. I mean, I'm not a lawyer, but it's a lot of things going on in the court. So I agree with you on that. The government will say it's like for public school, how is it different? Yeah. So my cousin actually sent me a list of stuff that New York State is actually considering, and I got to look at all the stuff on that. But yeah, because a lot of things that this thing says about OSHA applies to the flu, and it applies to the common cold. And Pfizer and Moderna, I think, are working on a vaccine for flu and cold, combined vaccines. So they might decide, you know what, we're gonna roll these in and force you to take those too. So don't be surprised. Don't be surprised. Um, so I think you just said you thought the mandate was back on. I think it is back. I think so it's back on technically because the stay has been lifted. They can still, again, while the appeal, I think the appeal is going to happen. I saw a government official, I think an attorney general from one of these states, said they're going to appeal. So it's back on. The thing it said, and that's why I said I was looking at the ruling that the judge put this on the employers. And I think that's pretty key here, is that they're saying it's not a vaccine mandate, it's a vaccine or test mandate. And if you have an objection to being tested, then the issue is, then you have a double issue. Now, me personally, I'm not against being tested as long as it's not that thing that goes way back into my throat like I did when I had the flu. Yeah, that's not something I'll subject myself to. The other testing I've done, they just kind of clean my nose for me, and I'm like, thank you very much. Thank you for cleaning the snot out my nose. So I mean, but there are people who object to that, and I respect that. So I would say personally for the employers and for you got to do with your employee, if you're an employee, is decide, you know, what's the lesser of two evils if that's what you're dealing with. But your employer at this point gets to choose between the two, according to this particular ruling. And if you choose to not test, then they might have legal grounds under this to put you out. If you do agree to test, then you may be in the clear if that company gives you that option. But according to this, they don't have to. And I think that's a thing that's going to be important. So anyway, it's been an hour and a half, and I'm going to go. I want to thank everyone for coming in, and those who come and see us later, you're in for a long time. I might try and cut up some of these pieces so I can so it's easier to digest. But thanks a lot, and I'm gonna stop showing the document, and I'm gonna sign out. Ting and ting and ting and ting.